Okay, this is Douglas Pinkham with Pinkham and Associates. We are a dedicated family law firm here in Orange County, but we can assist you filling out your forms anywhere in the state of California. If you've gotten to this video, you're likely working on your judgment packet. This particular video is for a form that is only needed for a judgment packet on for finishing your divorce or legal separation case. Okay, so if you can see me right now and you see the form, that's fantastic. Some of you can see the form, some of you cannot. If you cannot see the form, then I would pause this video right now and get online and print out an FL130 form. It's called the Appearance, Stipulations, and Waivers. Print that out and have it in front of you. You can fill it out as I go along. It's a very simple form. This video should only take about 5-10 minutes. All right. So go ahead and get that form and then play it again, but I'll keep going now. So, just like every form, at the top of this form, you're going to put your name, address, telephone number. If you have a fax number that you've been using in your case, you can put that off to the side, but that's optional. The next line calls for an email address. Again, that too is optional if you don't want to put it in there. And on the line where it says attorney for, you're going to put your name in there. The next box starts out Superior Court of California, County of, and you're going to write in there or type in there the county in which you're filing your paperwork or in the county in which your case is located. Then you're going to put the street mailing address of the court that you're filing your paperwork in. If you do not know that address, it's quite simply available through Google quite easily. So look it up and put the correct address in there. Okay. Then at the bottom of that, after the address of the court, it asks for the branch name. Put in the name of the courthouse that you are filing in. This is not absolutely necessary, but if you happen to know it, put it in there. You can also look that up online. All right, next line, the next box asks for the name of the petitioner and the name of the respondent. Again, like I've said every time, the petitioner and respondent never change. If you were the petitioner when you filed the divorce or the legal separation or the case, you're always going to be the petitioner. If you were the respondent in the original filing, you're always going to be the respondent. And then it asks for the case number off to the right. By the time you're getting to this form, you absolutely already have a case number. So put that case number in there. Okay, next line. Number 1, appearance by respondent. This form is for the respondent. This box, excuse me, number 1 is for the respondent. Box A is marked only if you have never filed an initial or filed your response or appeared in court. That box 1A is saying, by filing this form, I am making a general appearance. That means it's the first time that you are legally presenting yourself to the court. If you have already filed your response with the court, then you are going to mark B because that was a general appearance. So you're saying I have previously made a general appearance. So if you have not filed any paperwork with the court, you mark A. If you've already filed your response with the court, you're going to mark B. If you are a member of the military, an active member of the military, you're going to mark C also. You're going to mark A or B and C if you're in the military. Now, if you mark C, you're going to need to mark a single box on the next form, and I'm going to do a short video on an FL130A following this video. And you're going to need to deal with that if you are an active military member. If you are not active, you're not going to need that, and you do not mark box 1C. Okay, moving on. 2, agreements stipulations and waivers, and it asks you to choose all that apply. 2A reads, the parties agree that this cause may be decided as an uncontested matter. All right, so if this is part of, and it will be, if you're making an agreement and you've put an agreement together, a stipulated judgment or an old school mandatory or any kind of a settlement agreement that's written, if you have put that together and you're submitting this with the court as part of your judgment, then you're going to mark 2A because you want the court to help you end your marriage and give you a divorce without having to go to trial. So you want it to be done as an uncontested matter. 2B reads, the parties waive their rights to notice of trial, a statement of decision, a motion for new trial, and rights to appeal. So you're going to mark 2B if there's a settlement and you're trying to get this done without a trial, because you're saying, I don't need a trial. And if you don't need a trial and you're trying to settle this outside of court, then you also don't need a statement of decision because there's not going to be a judge. You're not going to need a motion for a new trial, and you don't need to appeal anything because you're not going to court. 2C reads, this matter may be decided by a commissioner sitting as a temporary judge. This is what I always tell my clients. Who cares who signs this for you, as long as they're legally allowed to sign it and a commissioner can. So mark C. Then 2D, the parties have a written agreement that will be submitted to the court, or a stipulation for judgment will be submitted to the court and attached to the judgment, which is the form FL 180, which there's another video on, and we'll get to that. You're going to mark 2D as part of your settlement, if this is part of your settlement package, and it is. That's what this form is for. So mark 2D. 2E reads, none of these agreements or waivers will apply unless the court approves the stipulation for judgment or incorporates the written settlement agreement into the judgment. I very seldom, almost never, mark 2E, and I'll tell you why. When you sign the judgment, you want your divorce to end. That's why you've signed this agreement. And because you want it to end, you want everything in this written agreement to be followed. That's the whole point of putting this together, is that you act on it, that you follow this agreement. And if you mark 2E, this agreement that you've written and negotiated and signed does not take effect until and unless a judge signs this form. If you do not mark E, it's good when you sign it. It's already good when you sign it, like a contract. And that's what you want. If for some reason you don't want it to take effect until the judge signs it, then you'll mark 2E. That's my advice on E. F, this is a parentage case, and both parties have signed an advisement and waiver of rights regarding establishment of paternal relationship, an FL 235 or its equivalent. So if this is a paternity case that you're ending by way of an agreement, you're going to mark that box. And you're also going to use the waiver of rights, an advisement of waiver of rights. It's just a form. You're just going to need to attach that form. It's an FL 235, FL 235. Okay. Then there's a box there for other. Very seldom you're going to put anything in there. I can't remember the last time I put anything in that box whatsoever. This form is pretty straightforward, and nothing else needed in that box. If you believe there's something else needed in the number 3 other box, call an attorney and get a little bit of specific advice on your specific case to find out if you should or need something in there. Then, very simply, you're going to date. Okay, so the petitioner's name goes there on the top, and the petitioner signs to the right, and you're going to date it to the left also. then the respondent's date, handwritten name, and signed name to the right. If you had attorneys, they would be signing below. But if you're doing these forms on your own, you likely do not have an attorney. All right, folks, that is it. Pretty simple form. That is the appearance, stip, and waivers, FL 130. Well, thank you very much. This is one video in a series of videos to help you put together your judgment outside of the assistance of an attorney or court. So I hope this video was helpful for you. Have a nice day.